not decline to provide services to an otherwise eligible small business concern under this section solely because such concern is a cannabis-related legitimate business or service provider. D. Section 8(b)(1)(b) of the Small Business Act of 15 U.C. 637(b)(1)(b) is amended by adding at the end the following new sentence. The head of the school program established under this subparagraph may not decline to provide services to an otherwise eligible small business concern solely because such concern is a cannabis-related legitimate business or service provider. E. Veteran Business Outreach Centers, Section 32 of the Small Business Act of 15 U.C. 657(b) is amended by adding at the end the following new subsection. H. Services for cannabis-related legitimate businesses and service providers. A veteran business outreach center may not decline to provide services to an otherwise eligible small business concern under this section solely because such concern is a cannabis-related legitimate business or service provider. F. 7(a) Loans, Section 7(a) of the Small Business Act of 15 U.C. 636(a) is amended by adding at the end the following new paragraph. 37. Loans to cannabis-related legitimate businesses and service providers. The administrator may not decline to provide a guarantee for a loan under this subsection to an otherwise eligible small business concern solely because such concern is a cannabis-related legitimate business or service provider. G. Disaster Loans, Section 7(b) of the Small Business Act of 15 U.C. 636(b) is amended by inserting after paragraph 15 the following new paragraph. 16. Assistance to cannabis-related legitimate businesses and service providers. The administrator may not decline to provide assistance under this subsection to an otherwise eligible borrower solely because such borrower is a cannabis-related legitimate business or service provider. H. Microloans, Section 7(m) of the Small Business Act of 15 U.C. 636(m) is amended by adding at the end the following new paragraph. 14. Assistance to cannabis-related legitimate businesses and service providers. An eligible intermediary may not decline to provide assistance under this subsection to an otherwise eligible borrower solely because such borrower is a cannabis-related legitimate business or service provider. I. State or local development company loans. Title V of the Small Business Investment Act of 1958 of 15 U.C. 695 et seq. is amended by adding at the end the following new section. Sec. 511. Loans to cannabis-related legitimate businesses and service providers. The administrator may not decline to provide a guarantee for a loan under this title to an otherwise eligible state or local development company solely because such state or local development company provides financing to an entity that is a cannabis-related legitimate business or service provider, as defined in Section 3(ff) of the Small Business Act. Sec. 8. No discrimination in the provision of a federal public benefit on the basis of cannabis. A. In general, no person may be denied any federal public benefit as such term is defined in Section 401(c) of the Personal Responsibility and Work Opportunity Reconciliation Act of 1996, 8 U.C. 1611 accede on the basis of any use or possession of cannabis, or on the basis of a conviction or adjudication of juvenile delinquency for a cannabis offense, by that person. B. Security clearances. Federal agencies may not use past or present cannabis or marijuana use as criteria for granting, denying, or rescinding a security clearance. Sec. 9. No adverse effect for purposes of the immigration laws. A. In general, for purposes of the immigration laws, as such term is defined in Section 101 of the Immigration and Nationality Act, cannabis may not be considered a controlled substance, and an alien may not be denied any benefit or protection under the immigration laws based on any event, including conduct, a finding, an admission, addiction or abuse, an arrest, a juvenile adjudication, or a conviction relating to cannabis, regardless of whether the event occurred before, on, or after the effective date of this Act. B. Cannabis defined. The term cannabis, 1 means all parts of the plant Cannabis sativa L. Whether growing or not, the seeds thereof, the resin extracted from any part of such plant, and every compound, manufacture, salt, derivative, mixture, or preparation of such plant, its seeds or resin, and a 2 does not include the hemp, as defined in Section 297 of the Agricultural Marketing Act of 1946. B. The mature stalks of such plant, fiber produced from such stalks, oil or cake made from the seeds of such plant, any other compound, manufacture, salt, derivative, mixture, or preparation of such mature stalks except the resin extracted therefrom, fiber, oil, or cake, or the sterilized seed of such plant which is incapable of germination. Or seed any drug product approved under Section 505 of the Federal Food, Drug, and Cosmetic Act, or biological product licensed under Section 351 of the Public Health Service Act. C. Conforming amendments to Immigration and Nationality Act. The Immigration and Nationality Act and 8 U.C. 1101 et seq. is amended 1 in Section 212H by striking and subparagraph of either of such subsection insofar as it relates to a single offense of simple possession of 30 grams or less of marijuana, 2 in Section 237(a)(2)(b)(i), by striking other than a single offense involving possession for one's own use of 30 grams or less of marijuana, 3 in Section 101(f)(3), by striking except as such. Paragraph relates to a single offense of simple possession of 30 grams or less of marijuana, 4 in Section 244, c(2) of 3(i), by striking except for so much of such paragraph as relates to a single offense of simple possession of 30 grams or less of marijuana. 5 in Section 245H(2)(b) by striking except for so much of such paragraph as related to a single offense of simple possession of 30 grams or less of marijuana. 6 in Section 210(c)(2)(b)(2) by striking except for so much of such paragraph as relates to a single offense of simple possession of 30 grams or less of marijuana, and a 7 in section 2450D2. B2 lied by striking, except for so much of such paragraph as relates to a single offense of simple possession of 30 grams or less of marijuana. Sec. 10. Resentencing and expungement. Aid expungement of nonviolent federal cannabis offense convictions for individuals not under a criminal justice sentence. -1 in general. Not later than 1 year after the date of the enactment of this Act, each federal district shall conduct a comprehensive review and issue an order expunging each conviction or adjudication of juvenile delinquency for a non-violent federal cannabis offense entered by each federal court in the district before the date of enactment of this Act, and on or after May 1, 1971. Each federal court shall also issue an order expunging any arrests associated with each expunged conviction or adjudication of juvenile delinquency. 2. Notification. To the extent practicable, each federal district shall notify each individual whose arrest, conviction, or adjudication of delinquency has been expunged pursuant to this subsection that their arrest, conviction, or adjudication of juvenile delinquency has been expunged, and the effect of such expungement. 3. The right to petition court for expungement. At any point after the date of enactment of this Act, any individual with a prior conviction or adjudication of juvenile delinquency for a non-violent federal cannabis offense, who is not under a criminal justice sentence, may file a motion for expungement. If the expungement of such a conviction or adjudication of juvenile delinquency is required pursuant to this Act, the court shall expunge the conviction or adjudication, and any associated arrests. If the individual is indigent, counsel shall be appointed to represent the individual in any proceedings under this subsection. For a sealed record, the court shall seal all records related to a conviction or adjudication of juvenile delinquency that has been expunged under this subsection. Such records may only be made available by further order of the court. B. Sentencing review for individuals under a criminal justice sentence. -1 in general. For any individual who is under a criminal justice sentence for a non-violent federal cannabis offense, the court that imposed the sentence shall, on motion of the individual, the Director of the Bureau of Prisons, the Attorney for the government, or the court, conduct a sentencing review hearing. If the individual is indigent, counsel shall be appointed to represent the individual in any sentencing review proceedings under this subsection. 2. A potential reduced resentencing. After a sentencing hearing under paragraph 1, a court shall expunge each conviction or adjudication of juvenile delinquency for a non-violent federal cannabis offense entered by the court before the date of enactment of this Act, and any associated arrest. B. Vacate the existing sentence or disposition of juvenile delinquency, and if applicable, impose any remaining sentence or disposition of juvenile delinquency on the individual as if this Act, and the amendments made by this Act, were in effect at the time the offense was committed. and a C. The order that all records related to a conviction or adjudication of juvenile delinquency that has been expunged or a sentence or disposition of juvenile